All right, thank you. I'd like to start this off and call to order the Thursday, September 20th, 2018 Watertown Board of Adjustment meeting. Can I get a roll call?
Dargis Johnson?
Here.
Culhane?
Here.
Dolly?
Here.
Johnson? Or Hanson?
Here.
Stein?
Here.
Kays?
Here.
Ford?
Here.
We have one absent, and that would be Olson.
And just for clarification, does that mean Diana can vote
Yes.
then today?
Yes.
Perfect. So first item on the agenda is the approval of the September 6, 2018 minutes. Can I get a motion, please? Motion by Stein,
Second.
second by Dargis Johnson. All in favor?
Aye.
Opposed? Motion passes. Item 2 on the agenda is an application number 19237. Joe?
The owner applicant is Samantha Schwalm for Schwalm Corporation, doing business as The Lounge at 21 North Maple. The conditional use request is that the applicant seeks approval to continue the sale, serving, and consumption of alcoholic beverages and the operation of video lottery machines in the C1 Community Commercial District pursuant to 21-24034 bar or tavern, contingent upon compliance with 2.0102 location and specific rules governing individual conditional uses, which is 21-0202 2B7A through H. This property consists of a 7,170 square foot circa 1912 commercial building with a 3,585 square foot footprint located on a 3,585.53 square foot parcel. The parcel has been previously operated as a bar tavern, but staff could not find site approval for the use. So the staff findings are that bar or tavern is a listed conditional use for the C1 Community Commercial District per 21-24034. The definition of bar or tavern is any establishment, including restaurants and gambling establishments, licensed to sell alcoholic beverages for consumption upon the premises where sold or provided. The term bar or tavern shall also include establishments licensed to sell alcoholic beverages for consumption off the premises where sold. The applicant submitted a floor plan showing the interior layout of the bar, seating, and video lottery area of the 3,585 square foot main level, and site plan which reflects or does not reflect the following requirements of the ordinance. Section 21-0202 2B7A through H is the specific rules governing individual conditional uses, such as ingress-egress of the property, off-street parking, loading, screening, buffering, signage, refuse, exterior lighting, required yards and open space, and general compatibility. 2.0102 location. The C1 Community Commercial District is exempt from this restriction, so we don't have to talk about that. Chapter 2163 is off-street parking and loading requirements. The C1 district is exempt from off-street parking requirements also. Chapter 2165, outside storage and display requirements for specific uses. Outside display was not indicated on the application or in the application. Chapter 2173, landscape and lighting standards. This property has 0 boulevard grass and trees. However, this portion of the C1 district is also exempt from these requirements to the extent that it currently complies. Chapter 2180, signs and outdoor advertising. Again, signage was not addressed in the application. It apparently is staying as is and has been for quite some time. This board must determine if satisfactory provision and arrangement has been made concerning 21-0202 2B7A through H and the chapters described that I just described for bar tavern to continue to be operated at this location.
Thank you, Joe. I'd like to open the public hearing. If anybody's here to speak on behalf or against, go ahead and approach the microphone.
Ken Buholtz. Just FYI, we would never pull the liquor license away from these people. It'd be grandfathered in and be there forever, regardless whether we came to the board or not. But it's just we're coming to the board to make it legal and put it on paper so that they have the advantage for loan or insurance or any other reason. They can show them in paper that it exists.
So Ken,
basically, once this happens, whoever buys the bar and transfers the liquor's license, we don't have to see this again as another bar conditional use?
No, once we grant the liquor license for a piece of property, we've granted it for the property forever in perpetuity. Actually, it has to go to the city council for the transfer of the liquor license in or out, and they have a second chance or option to do it if they want to do it for that thing. We're just saying that the land is blessed and it is allowed to have the liquor license on it.
But from the perspective of the land use being a conditional use for a bar tavern, the issuance of this bar tavern is going to the applicant, or are we tying it to the land? So if somebody else wants to open up a bar and tavern, that we don't have to go through this morass again?
We want to tie it to the land.
Okay, thank you.
Yeah, I was a little surprised to see that it wasn't covered, since this has been operated as a bar tavern for decades.
Used to go to Palomino many
Yeah.
years ago. So.
In fact, I think I recall when this came before us last time for the remodel in 2013, and I thought it was discussed at the time, but it must not have been. It must have been assumed at that time as well that it was already granted. So it seems like it's more of a housekeeping.
Yeah, and if it would ever cease to be a bar for more than a year, the conditional use would go away. And then a future owner would have to come back and ask for a conditional use again.
Seeing nobody from the public coming forward, I'll go ahead and close the public hearing and look to the board for further discussion.
I'll make a motion to approve the conditional use as presented, with the caveat that any outdoor signage would comply with the city's code.
A motion by Kays, second by Colhane. Any additional discussion? All in favor?
Aye.
Aye.
Opposed? Motion passes. Item 3 on the agenda is application number 19238. Jill?
The owner applicant is Jeff and Sandra Stodham. The address is 308 and 3012 5th Street Southeast. The actual structure that we're talking about is on 312, which is this area right here. Applicant seeks approval for modification of site plan for a previously approved conditional use to allow for an unlawful 414 square foot roofed porch addition onto an existing non-conforming retail building to be permitted after the fact, contingent upon compliance with specific rules governing individual conditional uses, including but not limited to 210202 2B7A through H. Concurrently, the applicant appeals and seeks variance relief from 210302, which prohibits the alteration, modification, and/or enlargement of non-conforming structures. The neighborhood retail establishments, as defined by ordinance, is a listed permitted or conditional use in the R2, R2A, R3, and C2 districts, while retail establishments, as defined by ordinance, is neither a listed permitted nor conditional use in the R2 single-family attached residential district. It is listed in the C1, C3, and BP districts, BP being business park. Nevertheless, the BOA granted conditional use approval to allow this retail establishment and the expansion of it in the R2A zone previously. The definition of legal non-conforming building is a building which does not comply with all of the regulations of this ordinance or any amendment hereto governing area and bulk for the zoning district in which such building is located, but which was constructed with a lawfully issued building permit. This definition shall not be deemed to include structures for which no building permit was issued or obtained. The site plan and written request provided reflects compliance or non-compliance with the following requirements of the ordinance. 210202 2B7A through H is the specific rules governing individual conditional uses such as ingress, egress, off-street parking and loading, screening, buffering, signage, refuse, exterior lighting, required yards and open space, and general compatibility. The new fence screening in the northwest corner of 308 5th Street Southeast is not shown on the site plan that was submitted. The building official will address this in a few moments. Chapter 2163, off-street parking and loading requirements and engineering design standards. The alley is used to access customer parking. The paving of the alley may be considered as a condition. Chapter 2165, outside storage and display requirements for specific uses. Outside displays of merchandise is permitted, and outside storage may be, with approved screening. Neither were addressed in the submitted application. Chapter 2173, landscape and lighting standards. Minimally parking lot screening from adjacent residentially used property is required. And Chapter 2180, signs and outdoor advertising, signage was not addressed. This board must determine if satisfactory provision and arrangement has been made concerning 210202 B7A through H and the chapters reviewed previously. This parcel lacks standard boulevard requirements. If application is endorsed, this board may consider requiring fulfillment of the lacking boulevard requirements and/or any other conditions of approval deemed necessary, such as limiting outside storage, displays, and parking areas, paving of the alley, screening, etc., in conjunction with any authorized structural improvements. Chapter 219901 and/or Section 21020222F may also be exercised.
Thank you, Joe. I'm a little confused from a process standpoint, how we get to the point we're at today, seeing that we did talk about this again approximately 6 months ago. Yep. And given the actions that we took on that date. So it seems as though we're back reviewing the same request a second time. Is that in line with the processes that we've typically established for this?
This application that is before you is a brand-new application. It follows a long history of this property and things that have been done to it with or without building permits. But what we have before you today is a new application stating, yes, we have this structure. It was unpermitted. Can you bless it after the fact?
So it's the same structure we talked about before, but the request is that they want to permit after the fact today.
The structure actually wasn't talked about before, except in the fact that we brought it to you as a follow-up, that it hadn't been on the last application to the board. It actually
Right.
wasn't on there, the structure itself.
It wasn't on the original request.
Right, the previous request.
But if my memory serves me correctly, they were instructed to take it down, weren't they?
That's correct.
And adjust the fence.
Correct.
I didn't look real closely, but I don't think either one of those things have been done yet, have they?
Correct. Neither one have been done.
So how are we here when instruction has already been given? I don't know how it's supposed to go forward.
Can we legally ask for this or not? The opinion of the attorney is that we can come back and legally ask for this in front of this board. I guess it's still up to you to make that decision of whether it's going to be done or
So if we were
not.
to deny the permit today, their existing permit is non-conforming with the terms of the ordinance, they have a legal non-conforming use,
No, the use is allowed.
but they're not in compliance with the ordinance, so how can it be
They're,
conforming?
believe it or not, they are totally in compliance with the ordinance with this structure. Now, I'm not talking about everything on the property, but this structure is conforming in setbacks and it's built and everything else. It was just built without a permit. And the original request was for me to have it tore down. And when it came to the board last time, the board did not rescind my request to have it tore down. So they just left my requirement in place. We gave them 180 days to do it, and it hasn't been done. They're coming back and re-asking that if we can leave that portion in place and just pay the applicable permit and fine. Typically, if somebody comes before me and I catch them building something without a permit, they get double fined. So if it costs $500, we charge them $1,000. That's the typical scenario.
Last time there before you, it was an appeal from his decision. This time it's actually a request. They're basically making the request as if it's not actually presently standing, which it actually is, but.
So the appeal from his request came to us as the board. The board instructed the applicant to do what Kenny said.
Right.
Build it and tear it down, build the one thing or tear them down, whatever it was. And they failed to do that in the time frame. So if we don't act on the request today, they're still not in compliance with our original action of 6 months ago.
Correct.
Therefore, then they
So
would be
if
non-conforming to the use.
If you don't act on it now, then it'll be a process that we have to go through the court to do.
Okay.
There's a public hearing too?
Yeah, I have not opened the public hearing, but I'll go ahead and open the public hearing if there's anybody to speak on behalf or against. And if you would, state your name for the microphone.
Yeah, I'm Larry Lanning. I live to the north of them. Everything that they do, they've never had a permit. They virtually had the number 2 done before they came and got a permit to come to see you guys for the variance. It's been that way with everything. So we've had issues with the fence, everything. So just stick by your guns.
I know we did have issues with the fence, and then we'd further instructed them to, I think, raise the height of the fence along your property line to 8 foot. Was that completed
That's
to the
complete.
requirements? Then the further issue with the fence that we discussed 6 months ago was that it wrapped around on the front side, which wasn't part of the building permit that they were granted, and they were advised to remove that as well.
Well, no, they were granted that permit, but they were supposed to do it with a clear view triangle because of the driveway, and they didn't do that. They just built it full 7 foot or 6 foot tall and didn't.
That's right,
And left
because
the-
there's a driveway there, and it comes up rectangular right to the edge of the
Correct.
boundaries.
And she parks there every day, so. Behind the fence.
So Kenny, if they were to fill in that approach, the fence could stand.
Fill it in and remove it, yep.
Or barricaded, I think we talked about it. They barricaded it.
And my recollection was either they don't use it and barricade it, or they fix the fence such that there was a clear view triangle.
And the overhang is the other issue in the back. That point, could you point to it, Jill, with the other thing that they built that they weren't supposed to?
Right, it's right about in here.
It's not on this picture yet.
Okay.
I will bring it up. That is.
So our option is to simply bless after the fact, or deny, and then it goes, then it's a remediation or a whatever you call it.
Yeah.
Are there, I know, I read it and I was getting confused going back and forth in the different time era that was going here. So all of the sheds and everything else, those are conforming with the rules and regulations?
No.
No, but the minutes from the meeting where this addition was granted approval, in that meeting, I believe, that was the one where all of the sheds that have appeared on the property that haven't had a building permit were granted approval, but they could have no more sheds. So
Was
they
there
were-
objections from the neighbors at that point in time during that public hearing process?
I can look.
The original variance to make it a business rather than residential.
That was my other question. I was trying to understand, a previous board granted a conditional use or a variance to allow this use, which isn't technically allowed within the ordinance. It's basically a use variance.
Yeah.
Okay.
Yeah, that was done in 1992.
Kenny, how's that canopy classified? Is that an extension of the primary structure? Is it accessory structure?
No, it'd just be an extension of the primary structure.
Because it's attached?
Yeah. It'd be considered as part of the primary
And the
structure.
primary structure meets all the setbacks currently, as far as side and yard, rear and front?
That structure does. And so does the lean-to, amazingly enough.
But the sheds probably don't?
No, those 3 sheds along south, the bottom of the screen, when it's south on that one too, also do not, so.
Do we have the ability to horse trade?
Do they have the ability?
In what sense?
Make those sheds and some of the other things that are maybe more objectionable to the neighbors go away in forgiving the conforming structure that's been added onto the primary structure.
Can they grant this, but say they gotta remove this?
I mean, you've got illegal non-conforming structures that are located on the property. We're being asked to approve one addition to a structure that would be conforming, and also asking for another structure that's non-conforming. So if we want to allow one, why can't we get rid of some of the others?
Yeah,
I guess-
I don't see any reason why you couldn't.
My issue with that is we've asked them to do a lot of things that are not getting done, so we're just asking more, and it's probably not going to get done, so.
I agree with you totally, Rhonda. I think the issue here, rather than a structure here, a structure there, are the history of what they have been asked to do, what they haven't done, and what they claim they didn't know anything about after the fact. And the neighbors who are looking to us to provide them some relief from what they obviously has been a painful experience.
What are those?
I have had the neighbor to the south contact me and complain about those sheds that are too close to the property line there, just in the past, so just an FYI. I've also pointed out one more issue with this time that's a little bit different than the last time. There is a provision within the ordinance that does allow the board to assess a $25 a day per fine if the actions aren't carried out within the time that you designate.
So any motion that we would make, we would clarify then a time frame and state that that fine would apply for each day past that time frame that it wasn't completed.
Or are you saying that we assess a fine based on the time frame that's already been violated?
No, I would just say it was not brought in.
We can't hear you, Ken. What did you say?
I would just try to keep it moving forward for what we've done, or what we'd hope to do or plan to do.
So if there is a fine available, does that have to be part of the board action since it's an ordinance? Or why wasn't that applied to this noncompliance?
It is a board
Issue.
action that's allowed to be taken by the board.
So that we have to take that action specifically in order for the fine to be applied.
Correct.
Can it be applied retroactively to what they were ordered to do
I
and
think
have not been done?
I think you're hamstrung by statute that says
Well,
that.
I'm
anybody-
asking the city attorney that question.
I don't know what he's referring to in the ordinance.
By the way, what he's reading is on the back of your report.
I don't believe it could be done retroactively.
Okay,
It'd have to
thank
be
you.
done in your action
All right.
going forward.
Jill, I have a question. You mentioned a minute ago that previously the board did grant a variance for the sheds. So how do we retroactively, if you want to do the horse trading thing, how do we? Right.
If they were here, you could maybe have that discussion with them. But if
Okay.
I think those sheds have already been approved as part of their site plan, though, correct? As part of their conditional.
At one of the previous meetings, they were kind of grandfathered, everything that was in at that point.
Okay.
Yeah,
All three of those sheds were there. All three of those sheds were there.
Can they
at the
be
time of the-
ungrandfathered or not? I don't know.
correct. They were, should I read that portion to you? In the June 23rd, 2016 meeting where the, this addition was approved, it says that there was much discussion regarding unlawful permitted structures and the height, length, and extent of the screen fence. After several revisions to motions made, Stonebarger motioned to approve conditional to securing legal permits for the unlawful structures, no more accessory structures, and providing a mutually acceptable privacy fence up to 9-foot screening the residential property to the north.
So what were the legal permits for the non-conforming structures? What does that mean?
We, that was included when this permit number 16797 was signed off of.
You
Those,
blessed everything.
correct. That was included in the site plan.
And that's why I was asking for clarification on the canopy, whether it was considered accessory or part of the primary structure, because the language states no more accessory structures. So this is a compliant portion of the primary structure, meets the setback requirements of it.
Correct.
And just for clarification, those sheds were all put on there without building permits?
Originally, yes.
I also just did a clarification with the attorney that even if, so if we can't order them directly away, if you have an approval though of this, you can make a conditional upon him all by himself agreeing to take them away. Without actually ordering them away, but it can be a condition. If you want this, then you have to do this type thing.
Giving them the choice.
Right.
Now, does that include the new shed they put up next to their garage? Was that grandfathered in at the same time? Because that came in afterwards.
Is that right here?
At what time did that shed come in?
Or is this the one you're talking
Yeah, I
about?
think so.
Yeah, that was on the site plan previously.
All right.
Attorney, if we do some sort of goofy horse trading thing, does that obfuscate the remediation process or drag it out longer if we end up in the same position in 90 days or 60 days or 30 days or whatever it is? You know what I'm saying? Will it make it harder to get a court order, do you think, to tear it down?
I think you should put a deadline on. Just give them, if you give them a deadline for something for us to work off of.
Are we allowed to withdraw even the conditioned approval as a board? If the condition isn't met within the time frame? I mean, is it considered a withdrawal such that it wouldn't be?
It's part of
that
the
a court would
condition.
view it-
It's part of the condition.
We would
I
have,
guess my fear is that we delay the process, we give them another chance when they've had what appears to be a lot of different chances and have missed the deadline a lot of different times. And then we end up in the same situation, but we've actually hurt our position in terms of remediating the issue. I'm not using the right word. What is it?
Abating?
Abating. Yeah.
Abating?
I think the other thing, though, is, we can put some teeth behind the requirement specifically stating the fine, right, which wasn't done in the past.
Right.
And so as part of this conditional use request, we give them a time frame and state the fine.
And I completely agree with you, Commissioner Dolly. The issue is this is probably a civil fine, and we end up in the same position, too, where we have no real teeth. It has the appearance of teeth, but from a legal perspective, there isn't much real effective. I mean, people may argue with me about that, but
Either way, you end up.
yeah. Yeah.
What are the landings? What are you, landings, is that correct? What exactly are you actually looking for?
For them not to get away with it again,
Get away with it being what specifically?
without permits. They do everything without a permit. So,
Mr. Lanning, would you turn the microphone on? Is there a little green light or?
it's on.
He's just too far away from it.
I thought I spoke loud enough.
Sometimes they don't pick it up so good on the microphone.
But every issue, when they took over the Rasmussen house, she didn't come and get a permit until the week before the variance hearing. Am I right, Ken, about that?
I'd have to
A
reread
week or
it.
2 weeks before. The house was virtually done. And then, let's go get a permit so we can proceed. But they do that with everything.
I guess I feel that this is a business, and I don't know any other businesses in town that would continue to just, make fools of us, because that's kind of how I feel. We've asked them to do things, and I'm really not going to horse trade anything. I think we've given them 6 months here to get this done. They sat here and told us that they would have it done. They've had it all summer. We're looking at October here. And now all of a sudden, we're going to get motivated and get it done. I'm not doing any horse trading at this point. Any other business would just be forced to do it or whatever. I mean, I had nothing against the business. It's the fact that when you're asked to do something and just blatantly not do it, or
There
do
has
what
to
you
be
want to do,
consequences.
is,
is there a lot coverage requirement in this district, maximum lot coverage?
On the horse trading aspect, I mean, you could look at it as an opportunity to relieve a greater evil, though,
That's
as
kinda
well.
what
I
I'm
mean, if you
looking
could
at.
say, hey, we don't really care about your canopy. We should have asked, but we don't care about it. But at the same time, if you want your canopy, get rid of those sheds. Just as.
but are we not
thought.
just setting the precedence for the next business to come in, or homeowner, and just do what they want and ask for
Well,
forgiveness? I
hopefully
mean,
this board board doesn't make a stupid mistake that it did in 1992 and in 2016 that allowed us to move forward. I'm sorry, I'll take a swing at them. And so I think this is our opportunity to either try to right a wrong that was done by a previous board. And that's the only reason I brought up the horse trading. If we can make the other aspects of the lot become more conforming than it is correct currently today, I think it behooves us to do that. And so from my perspective, I don't care about the canopy, and I think the fence is an easy fix. You either put the barricade up, you don't park on it, or we start having the cops go by every day and ticket them for not parking there. And then if we can get rid of 3 of those sheds, if that's causing a problematic, or get them to move those sheds so that they are conforming with the city's ordinance, if we don't do something on a horse trading day, we're going to miss that opportunity until those sheds are burned down or blown away.
Yep.
And that's where I'm coming from. But I will go along with the.
I think it is kind of that lesser evil thing, right? I mean, is it better to have a canopy or the sheds that are sitting right on the lot line? And the fence.
Well, I see your point, truly. But for me, the principle of the building permit process does not involve a horse trade. And I think that, in my mind, if you look at the history as an example that we want to be strong and set and right the wrong, the small wrong that was done was back when all these exemptions and the permits and the afterthoughts were allowed. That's the small wrong. The big wrong was the building permit process was not followed. And I believe that's the message I want to present. Follow the building permit process.
Well, with that being said, why can't we horse trade and put, all the sheds go? All the sheds go.
I think your options, and legal counsel can help me craft this, but I think your options are either going to be deny their permit, which then moves it straight to circuit court, or we accept their permit with the horse trading. So if you want your pound of flesh for not doing the building permit process, we deny. If you want to try to fix the situation long-term, then we're going to have to approve their request with conditions, and that's how the conditions where we make the sheds and the fence go away. That's in my mind how I see it. So you can't have it both ways. It's a one or the other perspective.
Yeah, because if this would have come to you before it was actually erected, at that time, if they would have been sitting here, you could have horse traded with them at that time. So if you pretend it's not actually already there, that's basically what you're doing here.
So if it would be, are we positive that if we horse traded that this would go to court? Or not, I guess, or could it go to court and the court would say, well, I don't like that agreement. Yes, you can keep your sheds and you can keep your awning, and we're Board of Adjustment, that's too bad. Are we running that risk? I mean, it is a court,
I would have to go back and research all the actions that have been taken on this.
Okay.
I'm a little bit new. I know it's been going back to 1992 now. So, as far as what would happen in a courtroom, I'm not
So it's an
entirely
uncertainty.
positive.
We don't know that we
Right.
would actually get the result we wanted.
Well, if we put the condition on it, they could say, and who knows if they will, but they could say, okay, we'll tear down the sheds and leave our canopy up. Then we get what we want.
Is there a reason why the applicant isn't here this evening?
Has there been any contact at all with them?
They were both at the shop when we left our house.
Yeah, I mean, they were contacted many times through the process here, yeah. They were aware of when the meeting was and
But
everything.
they never reciprocated. They never reached out to you or anything like that.
Not that they wouldn't be here. I suspect they forgot.
The only instance in particular where I would support approving this would be in the instance where we did apply the civil penalty, although I don't think it's very effective. I mean, I think that we should have it on there, and the time frame be very small. Be a very small period of time with which to act, not 180 days. I'm talking 30, maybe 15 or 10, because I think that sends a clearer message. But outside of that, I don't think that we continue to allow anything like this.
Okay, can I just kind of rephrase, so I'm making sure I'm keeping up with everybody here? Okay, so we deny the permit, of which the expectation is the applicant will go to the next level, go to court, okay?
Well,
It'll be
the
on
next
us to
level,
enforce.
we'll be taking them to
Or-
court.
Okay, or we try to do some horse trading, of which if the applicant doesn't accept that, then we go to court anyway.
Correct. If we seek to, we'll have to seek to enforce our decision. So if the horse trade, if they don't do anything, they just leave everything up, then we would have to seek to enforce that. If you guys just deny the canopy, then if they don't take it down, we have to seek to get them to take it down.
And that time has passed, so if it's denied, our next step will be court, period.
And it's an abatement action. The city goes in front of the court and requesting the court to allow a court order to take it down, I think. I mean, I've never done one, but it's my understanding. But given what happened in Sioux Falls, and I haven't read the case real closely, but there's a Sioux Falls case where they ripped that house down. I think the city has some real teeth in abatement where it doesn't in other areas.
But this canopy itself is a conforming structure. And the risk that you have there is the court could say, well, that's a conforming structure, we're not going to force them to tear it down, correct?
Our process was, you have a conditional use. If you're going to change your layout, you have to come in front of us again and get permission. And so I don't see any reason why a court would not uphold that process.
It should.
Right.
You'd hope it would.
Right.
So then, from the board's standpoint here, strategically then, we're thinking that the applicant would be more likely to remove the sheds to comply and get their canopy approved than refuse to do anything.
And lose the canopy and lose the fence, both.
So when you're talking sheds, are you guys talking the 3, or are you talking all 5, or at least 4?
Mine would be, if I was to make the motion, which I'm not prepared to do yet, my recommendation would be to remove all non-conforming structures on the property.
Oh, that would be the 5?
I have no idea which ones are conforming and which ones aren't.
All non-conforming accessory structures?
Yes, and the fence.
And the fence.
Remove the,
I'm not making a motion.
no,
Yeah,
correct, I'm just looking for clarification, I'm sorry, but, so are you saying fix the fence or the curb cut, or?
I think if you remove the curb cut, then the fence is conforming, correct, Kenny? Kenny, I'm sorry. If they remove the curb cut, I don't think this blockading thing, it's removing the curb cut, the fence is conforming.
Correct?
At this point, in terms of the hearing process, do we close the public hearing or ask for more comments, close, and then ask for motion? Are we ready for that?
I'd like to have a question for Lanning first.
Okay.
Sorry. Again, as we're effectively trying to, strategize this, to use a former president's famous word.
W.
Rather than going for all of the non-conforming buildings on the property and making that untenable from the applicant's standpoint, is there something from your standpoint that would be something less than that, that would have a better chance of succeeding, of having them remove some but not all of the sheds, for example, if we were going to make that motion?
I didn't know the sheds were an option. I thought it was just the lean-to that we were talking about.
Right, but one of the panel's discussions
I
here is...
understand what you guys are getting
Yeah.
at, but they'll never move them and never tear them down. They'll just keep writing a check.
So your position is either, is we should go for the whole thing then? if
Go
we're
for the
gonna-
whole thing.
Okay. Understanding that may make it untenable from the applicant's standpoint, that he may just roll the dice and go to court and get it all in at that
Yeah.
point. Yeah.
Now, when you're gonna shut down the driveway, is that both driveways? That little parking area that she's got out front there too?
No,
Or
that's
just
not
one side?
non-conformance. There's no fence there blocking it or anything else.
The north curb cut.
Yeah, or the south one. So, yeah.
But to your point, if I might speak, there's an existing garage there that's an accessory structure that's probably been there for 50 years. It's only 4.5 feet off the property line that would have to be removed under that condition, and I would not like to see that.
I'm okay with that. I'm okay with that. Kenny, I'm okay with that. I'm talking primarily those portable structures.
Yeah, so if you make that in motion, be a clarify on that, please.
You'll clarify it for me.
I would also, I would encourage not including that curb cut in your motion either, because they're already required to do that by a previous action.
Okay. They just,
But they
Right.
haven't done it.
I don't know.
Where didn't you tell them to?
I just don't believe that the history of what has occurred on this property gives us any positive sense that if we go forward with asking them to remove, telling them, they have not been asked, they have been told, to remove sheds, et cetera, I think we are digging ourselves a huge hole. What in the history gives us any foundation or basis to say they're going to listen to anything we say? Nothing.
Yeah.
Except that they come and say, oh, after the fact, could you please bless this? And then aren't here at the meeting to give any input and let us know, after all of our debate and conversation, if this is something they would even remotely consider.
Yeah, I mean, we very well could offer it as a condition and they look at it and turn it down, and then we're in the same position where it's going to the courts, right?
Yeah, the end result of that is the same as if you would, as it would be if you were to deny it, in that we would just seek to take down the canopy. That would be the end result. If they just say, no, we're leaving the sheds, okay, the canopy comes down. If you guys deny this request, the canopy comes down. Same result either way, at least when you put that condition on it, there's a chance they might agree to remove the sheds.
So let me ask you guys, if you had 4 or 5 sheds full of merchandise and a canopy, which are you more likely to follow through on?
I think at this point, we'd look for a motion and go from there. Sorry,
Mr.
Chair, I keep.
Mr. Lang, did you have anything to add before I close the public hearing?
No.
We appreciate you being here today. Thank you.
Mr. Chair, before you close the public hearing, could I
Yep.
just try to put a bow on some of the discussion you've got here? And I think I'm restating some of what's been said, but basically, what you had, and I wasn't here 6 months ago, it sounds like you made an order that involved taking down some structures, including this particular canopy. Had they actually complied with that, as was the order of the board, they in theory could have come back and asked for this request. Essentially what they're doing is they're asking, let's just cut out the middle process there, let's ask for the conditional use, keep the canopy so we don't have to take it down to put it back up again. Had they done that, then the horse trading thing would have gone on, the same thing. If it's the intent, and it does make sense, we've seen other places say timeout, it's out of order for us even to say yes to this because of the fact that they haven't complied with anything we said anyway when we did that. And my only suggestion is, and of course the attorney can disagree with, can straighten me out if I'm wrong, but the suggestion would be that if you are inclined to vote no, that would probably be the line you want to go with, is that it's really out of order until what we ordered them to do the first time is taken care of. Then maybe we look at it. If that's the vote you're looking at, that's probably the direction. That's what I'm hearing out of at least one of the commissioners here.
Thank you, Luke. Go ahead and close the public hearing. Ask for a motion from the board. Kenny?
Reopen for just a second?
Yep.
The only thing is if we go to court, we'll only be able to get rid of the canopy. We won't be able to get rid of the sheds.
Canopy and the fence?
And the fence, yeah.
Canopy and the fence.
Can we,
So at that point, he could do the horse trading and say, okay, I'll get rid of the sheds and I'll keep my
we have-
canopy.
We have nothing to trade. That's my point. We say no. You can close the public, are we
no,
Yep.
well, I just, so from today forward, they haven't done anything with the curb cut. I mean, can we do the fine based on, I guess, can we start to charge them that $25 a day fine on the curb cut because that hasn't been separate from the canopy, or does it all have to be tied together?
I believe we actually have the power to issue them a citation right now, don't we? Besides the board action of $25 a day, isn't there a separate?
$200 a day thing?
Yeah.
I think the violation of a municipal code is a $500 fine plus 30 days in jail, and every day that it goes on that you cite them can be a separate offense.
Can be, yeah, so we do have the power right now to cite them.
Is there a reason we haven't?
There's never been the teeth to follow through with it and get somebody a $200 a day fine, and every day is a separate single new one. But if you're giving them a period of time, be it 10 days, 15 days, or 30 days, no more than 30, and then it's set in place, that's a different approach. It says, you know you're going to be fined if this trespass is past this point.
So the action that we determined to take today can align you on the direction you need to go as far as enforcement. And okay, I'll close the public hearing and ask for a motion.
I guess what I was just trying to get to is that the only thing that we have to trade, I think somebody's talking about horse trading, is if we trade, is the trade has to happen today. If we say no to their request and we go to court, and even if we win at the court, the canopy and the fence maybe goes down, but you don't have a chance, there's not another bite at the apple for the other things that are non-conforming, because this board, a previous board has blessed. Now granted, whether or not it was a legal action, that's something else completely different. They had the authority to do that, but they did. And we haven't done anything for 2 or 8 or 15 years, whatever the number is. So where I'm at with it is I would if the end game is court one way or the other, I'd like to position ourselves in a place that we can maybe get something more than just what we asked for 6 months ago. That's my opinion.
Yeah, my other thought is, had they done that in the right order, where they came to us asking for the conditional use, prior to building the structure, I think that's how the conversation would have gone, where we had looked at some of those non-conforming sheds and said that, yeah, you can build that canopy as long as you remove the sheds that are not in conformance.
I'll start. I make a motion to approve the request to allow the canopy to be allowed with the following caveat. That either the fence in the northwest corner of what's the address? 308 is removed or is constructed that complies with code, or the no parking is allowed on that spot, and the 3 sheds that are non-conforming in the southeast corner are removed from the property. And to instruct the code enforcement portion of the city to apply any applicable fines or legal actions to make sure that they are in conformance, all of which will start in 30 days from this meeting.
I have a motion on the table by Mr. Case.
Can we go 15 days?
How about we second it and then we'll have to discuss it.
I'll second you.
Second by Dargis Johnson.
I would accept a friendly amendment to 15 days.
The other question I have is, when you talk about code enforcement, does that include the fine assessment of $25 per day of 21.0202?
Whatever we have in the toolbox.
And what,
I believe we have to, it looks like
Okay.
when
So not-
granting a
not to
conditional
exceed.
use or variance, the Board of Adjustment may, as part of its official action, set an amount not to exceed $25 a day, so it looks like we have to do it.
I would accept that as a friendly amendment to the previous.
and what about the shed on the 308 property, the north property?
I believe, is that conforming? That is a conforming shed, I think.
The garage is, but is
The
that
garage is
shed's
not.
got to be too close, isn't it?
I don't-
This one?
That's okay? Okay.
So as a point of action, do we need to take a vote on the amendment that's on the table?
Or I think a substitute motion can be made, right?
I would accept as the bringer of the original motion and the comments made by my two esteemed colleagues to the west, I would accept that as part of my original motion.
Okay.
Now,
And do you second that?
you'd have to second it.
Okay. Any additional discussion?
So if this motion passes and 15 days passes, what can we expect? What exactly are we, that within 15 days the sheds will be gone? Or they'll make progress, or they'll agree to move them? Or what exactly can we expect within 15 days?
Mr. Chair, I would again come back to my original motion. The motion as the intent is that the sheds are to be removed. The fence is either torn down or constructed to conform with the ordinance, and there is no parking to be allowed on that pad if there are fences to stay there. And any of all those things happening 15 days hence results in them being out of compliance, therefore allowing the staff to enforce the ordinance as is. And that was also me instructing the city attorney to bring legal action for not being in compliance with an order of this board.
Would you just clarify whether that's calendar or business day?
15 days from the date, this date,
Calendar days.
15 calendar days.
Thank you, Todd.
Today is what is the date today?
20th.
5th of October.
And Rhonda, you had seconded that. Was that your understanding of the original motion?
That's correct, along with the fine.
Thank you.
Okay.
Seeing no additional discussion from the board, let's go ahead and take a vote. Can we do a roll call vote, please?
Hayes.
Aye.
Ford.
Yes.
Dargis Johnson.
Yes.
Culhane.
Yes.
Dolly.
Yes.
Hanson.
Yes.
Stein.
Yes.
Motion passes.
Thank you, Joe. Item 4 on our agenda is an open public comment period. If anybody's here to speak, go ahead and come up. I had somebody hiding behind the pillar one day, so I'm not sure. I think it's empty back there. Any old business, Joe? Take a motion to adjourn. Motion by Stein. Second by Culhane. All in favor?
Aye.
Opposed? We're adjourned. Are you ready, Brandy?
Eventually.
Yes, I am, if you guys are.
Yep, let's go ahead. Afternoon, everybody. I'd like to call to order the Thursday, September 20th, 2018 Watertown City Plan Commission meeting. Can I get a roll call?
Dargis Johnson,
Here.
Cohen,
Present, sorry.
Dolly,
Here.
Hanson,
Here.
Stein, Kays.
Here.
And Olson is absent. We have a quorum.
First item on the agenda is an invitation for public comment participants submittal. It doesn't look like we have anybody in the audience for that, so we'll move right on to number 2 is approval of the agenda.
We'll make a motion to approve the agenda.
Motion by Cohen. Second by Hanson. All in favor?
Aye.
Opposed? Motion passes. Third.
This doesn't have to be added to the agenda, but I just want to throw it out there for your focus anyways, that I would like to discuss R2A front yard setbacks again. I kind of did a little research and I just don't want to like throw that on you after Luke's presentation, and then you guys are like, great.
Okay.
So, yeah.
We'll bring
just
that up in
forewarning.
old business.
Yeah, yep.
Okay, so item 3 on the agenda is the approval of the minutes from the September 6, 2018 meeting.
So moved.
Motion by Cohen. Second by Dargis Johnson. All in favor?
Aye.
Opposed? Motion passes. Item 4, comprehensive land use plan, meeting number 3. I think that's you, Luke.
Sounds good. Okay.
Thank
Luke
you.
will take over.
Thank you, everyone, again for the third installment. Looks like we're going to have 4 of these installments, if not one more maybe. After that, I am Luke Muller, as you're aware, 1st District Association of Governments, here to review the comprehensive land use plan, which has, of course, been out on the city's website. We've been going through this. You're very comfortable with it. I, too, am very comfortable because today I'm on vacation, as you can tell by the way that I've unbuttoned this button right here. I feel very relaxed today. But I am here to present to you, so be ready with a quick wit. Here we go. In here, basically the same format we've been doing in the past. Today we get into a little more of where it was narrowly defined as far as what we were talking about, some things. I did want to recap. We spent a lot of time, of course, talking about what the lay of the land from a standpoint of what is going on the ground out there at the last meeting. We talked about current service areas of things. We spent a lot of time talking about parks. I did follow up and found out, and unless someone found different information, found out that the walk initiative, the 10-minute walk, did reference a half-mile walk. Made me feel much better for using that. I knew I got that number from somewhere. So that was with some of that information. And I asked Brandy, some of those things we talked about, we have been doing a formal adoption of those on the old business. I was just thinking that we may wait until one more meeting down the road to formally adopt what we talked about the last time, just to instruct me.
Okay.
That's just for later on. So the thing we're going to do today, review the document. And the items we're going to review, and I did swap this. I wish I'd have given you a little more heads up on how I was going to talk about this, but we're going to talk about future land use of the redevelopment area, the existing part of town today. And then the other thing is I'm really just going to show the table in the implementation section in 170. I think the page is 172 is where it starts. Where it references, what it does is it references within the future land use map within the developed areas. There is a color that corresponds with each color on the map, and it gives a recommendation as far as zoning districts that may apply to that and that sort of thing, as well as examples of what that sort of development would look like. I really want to point you to that so that I know that you've looked at that very closely for the next meeting. I was kind of hoping to talk about it here, but I really don't think there's a prayer we're going to spend a whole lot of time looking at that today. So we'll point at that right before I go here. So today, getting into it, we're talking about the future land use in this area, in this portion. We've got the section 136 to 140 really is an introduction to it. Identifies the fact that we've got a redevelopment, which is the redevelopment of the existing portion of town, part that's already annexed, versus the future development outside of town. Today we're talking about the redevelopment. It references some key points within that introduction, that we've got the expansion to allow for the expansion of intensive uses that we have out there, like the hospitals, Lake Erie Tech, the airport, some commercial uses and industrial uses. We referenced some unique forms of similar development. I spent a lot of time trying to tone down a way of saying that we got very informal today. We have a lot of land uses in town. We have a C3 district in which we use virtually every commercial use we have seems to find its way into a C3 district. There are, of course, neighborhood commercial and uptown, downtown commercial districts, but bottom line is we have a very general C3 district, but the C3 district on one end of 212 is not the same as on the other end. That's what I'm getting at, is that we have unique clusters throughout town.
And we've got C3 and C1 in areas that aren't not generally highway or central business districts.
Yeah, that's right. It sounds like someone did their homework in looking at it too, because that's exactly what we talk about within here. And really what it comes down to, the whole thesis statement of this section is that we're looking for pragmatic solutions to the land use transition areas. Bottom line is, even though, and I've harped on this a few times, and we've done this where we've updated on the fringe of town, because that's what the town wanted to look at. Even when this was done many years ago, I've thrown the number around about 40 years ago, even when this was done the last time, I think the argument could be made it wasn't really a pragmatic approach to what was going on, because the answer, if you look at the strategies, it was along the lines of kick them on their sorry bums if they're in the wrong spot, is what it amounts to. If they're in a non-conforming use, which, don't get me wrong, that's what the language says, is that if they're in a spot that should be zoned commercial but they're a house, kick them out of the house and make them rezone it. That's essentially what it said. And fact of the matter is, we had that policy 40 years ago. We didn't kick them out. And frankly, we're probably not going to in most cases. So let's take a pragmatic approach to what are we going to do in these cases. So that's the introductory standpoint. Really, in the beginning part, we just lay out there what do we mean by residential, single family. We're seeing 2.5 to 3 units per acre in future development. We do have up to close to 5, maybe even closer to 6 in some cases in developed areas of town on single family development. Multifamily, between 6 and 40 units per acre. Of course, when you're talking anywhere from duplexes to apartment complexes, that can be different up and down. It's not like it's a limit, but it's just kind of tells us that's a general range that we've got. Obviously, multifamily should work its way from higher intensive land uses as well as higher traffic areas. So you think about that, if you've got Collector Street or an arterial and you're going to have residential uses, let's not have houses out there. Let's have multifamily in those cases. Manufactured homes are going to be similar to single family, except for they're going to be a little higher density because they use a little bit less land, and sometimes they'll have a park closer to them. Commercial uses, we're going to be talking about clustered commercial development. Trying to avoid strip development, and that strip development is a term that we use in planning. Doesn't mean what some other people think it means. What that means is that it's the corridor development is what that is. We're trying to avoid a long stretch, a 3.5 mile long corridor of commercial stretch. We'd rather have clustered commercial development if we can help it, and that's really what we're going to strive towards. And that's within the previous plans. Also talking about embracing and encouraging unique neighborhood development so that we can point out and embrace the fact that the development on North 81 is different than the development on West 212 and is different than the development on East 212 and so on. Open the door for mixed uses. That's been taboo in this town for many years, to have mixed uses anywhere other than downtown here in town. Try to open that door so that we've got that ability, whether it be in the same structure or just within one sort of a campus, which we need to allow that ability since we've got some of those uses. As far as industrial uses, there's some general statements into there, but we really want them clustered into industrial parks so that we're not scattering particularly heavy industrial uses into areas that you have, say, large congregations of folks right next to a place where we're going to eat food or get our food or something along those lines. but just have some general things into there. They need to think compatibility with the adjacent land use, gradual transition if we can, proximity to arterial transportation, railroad access, and the ability to have large lots if need be. And then also we need to think about, can we economically provide services to these areas? So meaning that we can't be planning these things out on the very stub end of our water service area. We need to be planning within areas that we can serve them well. Public and quasi-public institutional information, we just pointed out within there that we're going to have, it's really been a trend that places are adding more quality of life items, and we've already talked about that fact. We'd like to see more parks. Or we'd like to make sure that we're developing, maybe not more, but in the same line that we have in the past as far as the number of parks. We also need to be cognizant of the fact that we do have an aging population that we already talked about. As that population ages, it's likely we're going to have more either higher density living, be it in assisted living scenarios or even just in shared living scenarios. So keep that in mind. A lot of those institutional uses do wind up being in residential areas. Last part from a general, and I'm really going fast on this conversation because this is only 4 pages, but it really lays out just kind of the general strategies behind this. Open space and ag uses, a lot of this really carries forward from the old plan. Probably the main things that are new in here are the last 2 bullets that you see on this slide. And I'm going to summarize them by saying that if nothing's going on there, we zone it ag today. Despite the fact that there are some things listed in our ag district that we'd just soon not see happen right next to our commercially developed properties in town. And also we've got some houses on lots, I don't know if you realize it, but your agricultural district in the town also has a 35-acre lot minimum in your town as well, just for example. Bottom line is, the suggestion in here is to have and this is something that's been talked about for many years in groups here, is that to have what amounts to it's a holding district is what it amounts to. I don't know what you're going to name it, but it amounts to a holding district, that instead of automatically zoning it agricultural, which is what most communities do, you'd have what amounts to a holding district, that the only permitted use on it would be essentially open space, big grass or current agricultural use or whatever the horticultural use. Anything other than that would require a conditional use or else a rezoning.
And Luke, you're talking about when land is annexed and zoned?
Correct.
That means that you have to bring it in with a zoning designation, but wouldn't you just zone it what our most conservative adjacent zoning is? And then at the time of preliminary plan, then we would look at all of that and their lot size is what they're planning on doing?
It depends on whether or not somebody's going to come in and they annex it, and it might be 3 years before they preliminary plan it.
Right.
So I think what Luke's trying to say is that right now, lots of times your ordinance by default, it's ag, right?
Mm-hmm.
And if we're going to have a default zone, just make it this future urban zone or whatever they call it,
Yes.
and you don't get to do anything until you come in with your preliminary plat and with what it is that you're intending on doing.
Yeah, exactly. Basically, there's no subdivision, no anything. It's that case where you're pulling in some property, but you don't have a master plan on it yet, or you don't have zoning tied to it. We, of course, do have some properties that wind up in that where we've had some where they annex one property at a time, say, despite the fact they've got a master plan outside of the county. That might help to alleviate that aspect as well, that they're doing it. I think that we understand here that zoning and taxation they're not the same thing. I don't think everyone understands that. It leaves the door open for that, as well as Todd had said, that if someone does have it in, but they've got some time to master plan, they haven't master planned it yet, it leaves that ability open. I agree. I think that it makes sense to have that conservative zoning next to it, but realistically, I'm going to call this the most conservative zoning because it's really just going to be grassland or nothing, is what it amounts to.
But otherwise, wouldn't we just look at the comp plan and what we're projecting that area be, and then just say, let's blanket zone at that instead of, because no matter what, they're probably going to have to go back and rezone.
Correct. They will have to go back and rezone. It could be. You could certainly leave it that way as well. That's why it's a policy. But the bottom line is that right now you don't have it in, you wouldn't have you wouldn't have that option to even put that tool in the toolbox. I don't disagree that you could do that as well, but there are parts as we get out to the fringe of how they want to handle it. In some cases you see that and they just throw a guess out there on how they're going to handle it. You're right, if they're going to rezone it anyway, they could just go to R3 today and say, well, I guess it's going to go R1. But that's one of the hang-ups that we do have. I think we all know how difficult it is to initially zone something at one level, and then once development happens up to that point, rezoning it to something different does become difficult. So it does put more pressure on the preliminary plan process. You're right, though, Brandy. So the last 2 points really dealt with the converse of each of those. They were just the opposite of those two. So that's what those amount to. The redevelopment plan itself, and that's basically what I call the first section of the future land use map, which is the redevelopment of the existing annex portions of town, splits the town into 9 different groups, and those are basically, they go around the school districts as well as a couple of other portions that really had their own unique flavor as it amounts to. Within each of those redevelopment areas included some of those commercial strips that we had talked about. I believe there were 7 of those as well. And so whichever one of those redevelopment areas included the most of that commercial area, we talked about some of those strategies within that as well. As we went through in handling this, and I guess I should preface this. Sometimes not sometimes, pretty much every time, when you have a planner come in, someone from outside come in and help you within your office as far as drafting a policy document like this, we're doing a few things here. We're combining the policies, the decisions that have been made over the past many years. Some of the things that going back all the way to the last time that the zoning ordinance or the land use plan was adopted, you had a document that was called On the Radar that was out there. Some of those things that were talked about, hey, we ought to do this on a rainy day. Some of those things creep into here. Some of the things that we hear, hey, we granted these variances, wouldn't it be nice if we had a way to do this without doing that? Found ways to creep that into there. We held meetings where we talked to the planning commission about, hey, how would you like to handle this, that, and the other thing? Where are some of the important things? Where are some of the policies? That's where some of that came from. You also have an outside planner work on it to try and think of some of the things outside the box that you don't really think of on a day-to-day basis. So yeah, there may be a few things that come from left field, and that's why you're looking at it, making sure that that does make sense, or else that is a ridiculous idea and let's get rid of it. So I want to preface that as we look at these couple of there are certain planning considerations that ultimately we're repeating over and over again. And those are the ones that are on this slide. I didn't realize just how dark that bottom gets on there, so I'm going to, basically it goes down from a specifics to a general, but I think the main things that I'm really going to highlight on here, if there's one of them, I'll read the bottom ones here, but I'll highlight a couple of them that I think are they're newer concepts, and that is the reference to a specific civic use zoning district as well as a specific campus zoning district. The civic use zoning district and campus district are very similar. It's just a matter of the sort of use, and frankly, they could be the same thing. What it amounts to, that is it's really a dabble into what's called a form-based zoning, and some of these, that's what it goes into. All we're really doing in those cases is we're saying, here are the things that are going to happen on this property, and we don't plan on getting any closer than this to our edges. As long as we do that, are we good? Yep, okay. Then all we need is building permits after that. That's what it amounts to. That sort of thing would be designed to handle, and the reason that comes up, and we'll talk about that, we have some commercial uses that go on in residentially zoned properties in town. We have some commercial uses that go on in agriculturally zoned properties in town. And frankly, let's make them what they are. We also have some things that are just flat out not allowed anywhere, but they make perfect sense with the use that's going on. We also see uses that keep coming back to you and let's end that if we don't need to see them all the time. The last couple of them, adoption of a standard policy, I think this is something that's important. It was brought up in some of our meetings, and it's adoption of a standard policy for the conversion of private streets and utilities to public streets and utilities. This is not saying we need to do it. This is saying that if you're going to be doing it, someone in town needs to figure out what a standard policy is for that, and let's not just do it here and there depending on how we feel that day. We need to have a standard policy for that. The other point is aesthetic and access control should be placed on developments along major arterials and collector routes. And that can be as general or specific as you'd like, but that lays the foundation for some of these next sections.
Say, Luke, before you move on,
Yes.
Those bullets that you had there regarding the sidewalk plan and in regards to development, road projects, street projects, I'd like to also have some language in there in regards to our city parks that are not up to the standards in regards to sidewalk around the perimeter. That when we are engaging in adjacent development or something along the lines of encouraging the city to go back and redevelop the trail aspect of those city-owned parks as well.
So you're saying considering pedestrian transportation to parks from new subdivisions, any subdivision?
And old subdivisions,
Okay.
you know, I mean, so Highland Park, for instance, doesn't have sidewalk around the perimeter, and there's no real good way to get to it without walking in the street.
If we're encouraging non-conforming existing residential structures to be putting in a sidewalk, the city should probably, look in the mirror as well.
I mean, I've talked a lot about the Lions Park issue, but I mean, it's the case in almost every one of our parks in town.
Would it be fair to say that it would be a suggestion out of this board that the sidewalk plan needs to be updated?
I think that's a fair statement.
I mean, we talked about that at length last time. I think that's what I was hearing last time. All right, well, I'll move to some of the specific areas in here. There are a lot of pages and a lot of information in there. Realistically, let's start with Lake Compesca redevelopment area. That one we held specific meetings talking about a handful of years ago. The main thing that comes out of that is recommendation to have its own zoning district. I don't think there's any surprise that that's going to come out as a recommendation. At least that needs to address, and maybe they're all the same, who knows, but land uses which may be different from other residential districts, appropriate building materials, if that's something that needs to be handled, parking and outdoor storage, variability on setbacks, probably needs to consider is lot coverage, floor to area ratio for setbacks, lakeside versus roadside, how we're handling that sort of thing. The other 2 points involve our capabilities of providing services on a line that basically goes, and I'm going to apologize, it's on 449th Avenue, is basically, we had conversation that points out there's the ability to serve water, particularly on the west edge of the lake, is pretty limited. And so basically that area winds up being west half of the lake, or the land use part of the lake. And 449th, for what it's worth, is this one. Could be this one here. So basically, in that area to discourage development on higher densities, unless a study can be shown that indicates that we do have enough water service for whatever we're handling out there. So they may have to do more study. It's not shutting the door, it's just saying that we need one extra step in developing out that way.
Luke, is this where that portion where Pheasant Lane is located? In the previous comp plan, it was in there, like it was specifically that 20 more units could be added until a water tower would be necessary?
It was 50 is what it is, but yeah, and it does include that. Basically the line, and I said 449th, the line actually kind of goes diagonally from the time that we had talked about it from kind of like this way is the way that it was described to us. So yes, it does include that Pheasant Lane area as well, from a standpoint, and that's where if we have 2 or 3 lots to open up, it's probably not a huge deal. If we have someone propose a apartment complex with surrounding single-family houses, we probably need to have a study as far as what we're going to have into there.
Does this include on the south portion of the lake?
It would go diagonally again. So it would wind up going, and I think I went that for it winds up being. It would include to the south, but it's.
Can you show with your mouse?
Yeah, would you do it one more?
I'm trying to, and I can't. But there we go. Basically, that diagonal again, kind of goes from approximately this area to over here, is what it amounts to.
Where did that come from?
That was
Utility.
basically just the same. We had utilities do about the same thing, where they just use their finger on a map. And said it was about
Basically, the
this
utility department instructed us years ago in '93, and nothing has changed since then, that we have water service zones, and because of the lack of hydrostatic pressure, or I think that's the right term, we have the inability from a water pressure to get water into those areas without either adding another water tower.
And the statement was we have increasing ability as we get farther east in both directions. So the statement at the time was that there's really not a ton of worry in this area here, but as we get farther away, just understand we need to be more and more cognizant of the fact that we need to be paying attention to our ability to serve. And that study may include asking utilities, hey, do you have enough water? All the way up to, we need to do a full de-chilled hydraulic analysis of it. And it's just asking what that is.
How does that jive with this sewer river or the sewer issue too? Because isn't a lot of that stuff serviced by sewer?
Anything that's outside city limits is, and is served by sewer water. At least, actually, I think all the way around the lake would be.
But I'm thinking I've seen the map I saw it one time, but doesn't it include some of that stuff kind of in that Derby Downs region and west of Derby Downs? I mean, maybe not.
Yes.
Or is that all municipal?
But the north, any of the land that is not annexed on the south side of Derby Downs, that would all be serviced by sewer water. But I believe that the north is Cottington.
Is that Clark Rural Water?
Yeah.
I'm not sure where that line comes in. You're right, though. The initial maps that would have gone out in the 70s would have shown, say, Derby Downs into it, and would have shown where Derby Downs sits and some of the others into those service areas. Those have been handled since then in terms of swap. But as we look at it, you're right. The service areas as they go, and that may wind up having to be a consideration as we look at. And we already talked about that as development, just general practices, that we are going to have to work with rural providers as well and see if that needs to go into it.
Yeah, I'm not trying to suggest that anything's going to happen because I don't have any idea. I just, when I think of it, you think of that 4th Avenue West stuff where there's a lot of houses, and it's foreseeable that there could be some sort of attempted development north of 4th Avenue towards the lake. And I just wasn't sure how that fell in terms of even the whether it was Sioux River, or whether it was water that we could get to it or not, if it was city or would be city.
Yeah, right now it would wind up being, and I don't think it's too much for me to say. I mean, the policy isn't to extend water services outside city limits, and then we've got, you've got a much better map than I've seen. Mine was from 1970.
Okay. So, all of this very faint hatching is sewer water. So you can see it ends
It does end on that
right
west side.
there. And then the rest of this presumably is Cottington Park. And this was the map that I was talking about previously about referencing, but we can just reference that this map exists, and then, I mean, not to get too technical with our comp plan, because this is continuously changing when properties are annexed and whatnot. But at least it gives you guys an idea that this does exist. So if you're ever curious, or if there's ever an annexation and zoning, I can probably make this part of my presentation to make you guys aware.
Good point. There we go. So, I believe, have talked about the Compesca redevelopment area. For fun, let's talk McKinley redevelopment area. McKinley, again, school
I'm sorry,
district,
Luke,
yes.
we will have a statement in there that will talk about referencing the upcoming Lake Compesca study as well.
Okay.
And incorporating recommendations from that.
Good point.
What did you just say?
There, I got it.
Okay.
Good point. Yes, that will, we do need to have that into there as well. The McKinley redevelopment area includes the McKinley School District is what that includes. You can see I really just used the colors on this map to indicate where that area is. But the very first bullet and pretty much all of these points out that we have unique uses that need to be zoned differently. Generally speaking, those are the ones I was talking about where you could see a campus district or a civic use district depending on if you want to split those up or use them as the same. The complex, the Cook Complex, Kyan County Extension, Foundation Fields, Watertown Stadium, the Zoo, Derby Downs, not the subdivision, but the rodeo grounds, and things along, and the Watertown Regional Airport as another one. And just kind of thinking about those things that you've got either zoned residentially or agriculturally, and think about the things that go on in those areas. So those are some areas, not saying you have to do them all, but those are some things. And obviously we leave the door open for other things as you come up with them. Another point in here, we have the Watertown Airport. Recommendation is carried forward to have runway protection zones protected in some way, shape, or form with overlay zoning to make sure that if there are any runway protection zones that we do not, the city doesn't actually own, which the city owns a lot of it, that we have some form of overlay district and some form of review in those. Right now, I think it's a lot informal, but
Now we did just replat all of the Watertown Airport first subdivision, so all of the land that is under the airport's jurisdiction or the FAA is all there. It's all laid out now, so we dedicated additional right-of-way and vacated right-of-way, because previously there was, like, Golf Course Road was actually in airport property, so now that's all delineated. And then any, what are they called? There's easements too that we have over properties within the fly zone that you can't build a structure so high and you can't have open water and.
yeah, there are avigation easements as far as certain types, and there are also there's also a bowl shape. You have to think of this three-dimensionally. I've spent enough time talking to Todd Sire and Eric Dahl in my time to try and understand the fact that these runway protection zones on a map, they show up kind of goofy, but they basically are a bowl, is what it amounts to, that goes out in an angle about like this. So even though you're beside the runway, there's still a runway protection zone out there, though it's very rare for someone to peek up into that problem when they're off to the side. But anyway, the bottom line is to be able to review that. In some cases it's formal, some cases it's informal. Just make sure that we're paying attention to that. The other aspect is, and I have this in a lot of places, having the door open for if you do find yourself in a position where you are granting a whole bunch of variances in a cluster of areas, most likely those areas are going to show up where you have that cluster of yellow and red on that map, specifically the area between likely Kemp and 3rd as you head east, and then once you cross Highway 20, a little bit into that area. So having that door open, if you do find some unique characteristics within there, to have that ability to have an overlay district that would allow probably more of a lot coverage versus a setback, as long as you're meeting minimum fire codes and those sorts of things, if you need to review that. One of the other characteristics that we see in those areas, especially east of Highway 20, though we're vacating some of that, we have some wide rights of way as well. And so those are some things to keep in mind. We need to make sure we're protecting existing industrial uses from encroachment of incompatible uses. That's one of the things that sometimes is on its head, but people don't realize we need to protect industrial uses just as much as we need to protect residential uses. And then encourage and enhance perimeter landscaping, particularly on the edges of industrial developments as we see out there, say on collector streets and industrial or arterial, just to dress up the edges of those areas.
In this area, with there being residential R3, specifically adjacent to I-2 and I-1, would we want, in those cases, and I know we've talked before about having limited I-2 districts, but wouldn't we want to encourage the phasing out of I-2 and make it more conservative to keep stair-stepping it down to, and then have other areas come open where they're more appropriate? I mean, those pre-existed the residential development presumably, but that is kind of typical for cities that they grow around, and then, you try to keep maybe displacing it. And would we encourage that?
You're thinking displacement primarily by multi-person dwellings?
Well, and not even necessarily, but just if there was, like I brought up before, I think an old business where if, like I-2, if we were petitioned to rezone to I-1 to a more conservative district, that would bring some lots into conformity and it would make the district more restrictive. Would we encourage that? And how should we go forward in directing people with planning for their developments or redevelopments for that matter? Because I think that's a major point of this area.
You're talking primarily south of 4th Avenue.
Yeah.
Well, being that Mark's leaving here soon, we could redo his I-1 and then. Sorry.
Well, I mean, if
think
it's
you've got I-2 uses in that area south of 4th Avenue. I mean, there are some actual I-2 uses. That property historically was zoned I-2 because of the packing plant many, many years ago. There's vacant areas out there right now. I think I will just reiterate what I said. I think before we go out and we decide that it should be a more conservative use, I think we need some input from the economic development people in town to see whether or not we have enough I-2 zone property. That would be my preference.
I will note that's probably, everything Brandy's saying is right, is that generally we try to transition as much as we can from an I-2 down to residential. We really need to think about whether or not who we're protecting. Do we need I-2 zoning in town? I guess in what, from the past 10 years in here, what I've heard is when we have an I-2 use, they get kicked around town trying to find a place to go. And so, generally speaking, that's what I recall from some of those meetings. But I agree with Brandy in that we do need to figure out a way to transition, and a harsh transition from one to the next is difficult. So we either just accept the fact that there's going to be a harsh line here or work our way back. But I agree with that point that we probably need to have more in-depth conversations on an area.
And I don't think there's much of an issue, if it's development driven, if somebody's initiating a request that they want to build something, then the use case is there. I mean, they're going to occupy it, right?
I mean, if somebody wants to do an I-1 use, it's fine in an I-2 zone.
You might take the opportunity if they build a development to scale it down at that time.
I guess my question would be is to maybe have a conversation with Chris Shilkin and just ask him, is this a viable I-2 zone piece of property? If it's not, then you talk about going to an I-1, which would be a down zone from the I-2, and then the question would be then is have the conversation with the landowner to see whether or not they would be inclined to have that.
Yep.
Well, and too, like there are industrial parks on the perimeters of town that are sized appropriately to be rezoned to I-2.
However, some of them are restricted by covenants that they can't zone to I-2 uses. The business park is part of that, some of that, and there's some I-1 areas.
Prairie Ridge?
Yeah, there's certain, but that's all I-1 though, isn't it?
To. But BP is already zoned, that's already more restrictive than I-1 and I-2.
Right, but that's what I'm trying to say is we don't have any I-2 zone properties in the city, and so that could still be developed. And so my thinking is before we throw the I-2 out, is it a viable site? If it's not a viable site, then let the people that are, trying to promote economic development in the community tell us that. I'm not the one that's going to tell you whether or not that we should get rid of the I-2 zoning.
The replacement line is this bottom. It's this bottom bullet that's on there. In here it says encourage and enhance perimeter landscaping screening, depending on what meeting you're at. The enhanced perimeter screening. The bottom line is what we're talking about is buffering, is what we're talking about. Are we buffering by a gradual decrease in intensity, or are we buffering it just doing our best to use natural buffers or different types of buffers? And so I think that what you wind up doing is reference that as providing a buffer transition in between residential and industrial uses, particularly along that 4th Avenue stretch. That gives you can either point that out that we're going to work our way down zone, or else we're going to try to hide it. Let's be honest.
Well, but see, I don't know if that's viable either, because my main issue is the safety aspect of that. We did a disservice when we allowed R3 to be across the street from I-2, because if we're having a chemical explosion, it's not going to matter if,
You're right.
That's part of it, but also if I'm looking at having workforce housing, I want that workforce housing as close to my job location as well. So I think there's synergies that can be developed there by having multiple family dwelling or more intensive residential development near areas where you have job creation, and that's a very common focus.
Some of that's
children.
Pardon?
We've been going we're dealing with the I-1 and the I-2.
The issue in that I-1
adjacent.
and I-2 is that we don't want children playing and recreating inside an I-2 zone. That's different from someone living across the street or a half a block away from the I-2
What if
zone.
they have a bunch of kids that are playing outside, or they have a birthday party?
Well, hopefully their mom and dad are watching them, so they're not running over to the I-2 zone.
We have some of those uses, though, specifically with the chemicals and explosives as conditional, where you can look at it before you grant. It's not a permitted use in the I-2, right? So if you do have somebody that's proposing that kind of business,
I'm in complete.
if it's not, I mean, we can control it through a conditional use.
I'm in complete agreement with Brandy and Luke that when we're talking industrial uses, transitioning to less intensive uses when it comes to residences or busy streets, that's something that you aim for. However, this is one of those things we've been handed a pig in a poke here, and the question is, if it's not a viable I-2 site, this discussion, we're done.
That's a good point.
And so I think it's a discussion with the people that deal with this every day. We don't.
Mm-hmm.
Let them come back with a recommendation, and if they say, we don't care if that's I-2, then what Luke and Brandy says, I'm in complete agreement with.
Okay.
The primary commercial region that falls into here that was listed earlier in the existing standpoint, and I want to point this out, within those commercial discussions, there are a lot of aesthetic goals that are talked about within there. They really follow the spine of what the Gateway Overlay District follows as far as signage and aesthetic building materials, loading, those sorts of things, and they go from varying degrees is how that's handled, and I really am going to count on you to review those and see whether or not they match up. Some of that was written based off of sign codes that frankly we're not using anymore, so I'm going to go back through that. Some of it referenced having a lot of temporary sign under the temporary sign ordinance that we didn't have before. So bottom line is a lot of it referenced tie them up to the building and let's just leave them there. Well, that's not what we just adopted a rule that said that's not what we mean.
That was one of my questions. So we're going to revise that language, and
those
it kind
all have to be
of crops
revised.
up in all of
It
these
was
sections.
in every one of them. Yep. It was, and I can tell you when this went on, there was another draft of a temporary sign ordinance in which that was what the plan was. And so that's where that all came from. And so, yeah, that's going to get itself flushed out. The primary components here, you can see the 3 different colors of blue on there. The main setup and the main premise of this is that we can identify the fact that there are different things going on in different parts of this stretch here. Southern stretch is probably more the truck stop and farmer-oriented standpoint, as is some of the business that's more toward the north end of there. In the central part of that, we've got a little more community commercial standpoint that's going on. We may have the ability to do some neighborhood commercial down on the corner now where 10th and Highway 20 are. But basically, a commercial designation supportive of retail and rental or farm and industrial equipment or services, as well as highway-oriented retail should be retained in this area. Basically, a type of development that exists out there. We've got a wide variety. We're not saying to get rid of it all. Bottom line within the discussion, we talk about which is which. The southern ag production standpoint is likely to be more of a mixture of industrial and commercial uses. Frankly, that's when there's a highway commercial district, a lot of the towns that I work in, that's what goes on in a highway commercial district. What you see at Highway 20 and 212, that's a highway commercial district in a lot of the towns that I go to, aside from the fact there's usually an implement dealer there too. So that gives you an idea as to what sort of thing goes on there. Yes, the elevator usually isn't in it, but it's right next to it. So that kind of give you an idea of what that would be. Did you see anything within the McKinley or the Highway 20 redevelopment outside of industrial discussion that you really wanted to harp on and poke a fork at?
Just the idea of the C3 zoning on some of that, is it Kemp or that needs to be reconciled to what the actual uses are?
Yeah,
I don't know if you put that in there as just a carte blanche statement, Luke, but
yes, to have some of those on Kemp match what they actually are going on the property. Yeah.
1 second.
I'll see if I feel like that's covered through some general language or not as well. Here's what I want to do. We're at 6. Yes,
Okay,
Brandy.
in our major street plan, don't we designate Kemp? I'm trying to find it on here. As a major collector.
Likely. I don't have it in front of me. I think it is.
I'm trying to verify that this is Kemp.
I'm assuming it's a major collector route because it's
Yeah.
the primary east-west
Mm-hmm.
north of 4th Avenue.
But then wouldn't we, what zoning district do you foresee?
I would say we need to be creating zoning districts that match the use in the area that we are. I mean,
That's going to be a community commercial zoning
a
district.
highway
is what that's gonna
commercial
be.
zoning district is, I would think would be on a highway.
Yeah,
Right.
it's more apt to be a community or a neighborhood commercial district is what would be more appropriate there, as opposed to having auto repair shops and
I don't
that
think
sort of thing.
we have it quite fixed. I think that's the intent, is that we would look at wanting to just, if we don't have the appropriate zone, create the
Right,
appropriate
that
The-
it would be, it'd be more appropriate as C2.
Yes. Yep.
Yeah.
Yep. As it's listed today, but I would say that's.
And what's,
I don't think
yeah.
of the toolkit we have today. I would say C2 is probably the better fit for it. I would
Because
say that we
what's-
probably need to change that toolkit a little though.
Yeah, and because, right now when we look at, when we're presented with a conditional use or whatnot, we use a C3, and it isn't comparing apples to apples, but we have to because they have the same district. But
Exactly.
that area is not the same as Highway 20, or
You're right.
212.
You're right.
But yeah, so that makes sense.
And Brandy's pointed out that's really where we're going with a lot of this, is that we're not apples to apples on a lot of these. I'm not advocating having 37 zoning districts.
How many are you advocating, Luke?
36. No, basically what you really need to do is have the option to have what amounts to, you may need to have some overlay districts that ultimately treat the area near Highland different than the area near McKinley. Particularly the areas of Roosevelt School District or Millette School District that developed in the 1920s and are in the floodplain, we're going to have to find a better way than even R2A, which was a great fix. We're going to have to find another way than that. And we're really doing a good job with that so far, but I think that we're probably going to have to find even more to that. I want to get to this here. We're at 6 o'clock. Frankly, I've got a solid half an hour or better on this. What I would, if you want to go for that long, I'm happy to do so. Actually, I'd rather not. But the bottom line is we can. I think what probably makes more sense than doing that is that maybe I go to the back end of this. Let's flip to the back of the book and let's look at the maps, the future land use maps of the development of the redevelopment, and then point to the things as far as you just asked about. What are you talking about for zoning districts, Luke? I think it's important that we do look at that now, and then we can double back with however much time you want to spend on it. So I am going to go to these maps. What we have on a first map here is the general land use map. And the general land use map is just residential, commercial, industrial, and public uses. Public uses primarily following the existing public uses. Not a lot of planned new out there. Even the windows are ready. The areas that have some hatch in them, albeit on the screen, it actually shows up better than I had expected here, but the areas that have some hatch on there, you can see at the top with the key, we have commercial, residential. Those are mixed sorts of uses that we anticipate. I'm not saying that we have the same use on the same property. This is really putting the ball into the court of the board as it comes up. Sorry, this is one of those things that you love about planners, is that we say, hey, all right, it's your turn to figure it out when they come in. This is really our transition zone, is what it amounts to. Either of these things probably makes sense. What we need to be able to be cognizant of is the sort of thing that Brandy was bringing up, though, is that we don't want a tooth of industrial up into here and a house down here and trying to work around, hey, if we just stick a couple of trees in there, everyone will be happy. No, that's not how we do it. We got to try and think about how to handle that. The next slide takes that to another level. And so this is a specific land use map, and I don't think the colors are, well, actually, again, they show up pretty well. You got a good projector. The sorts of industrial, you can see a dark red, or more of a brownish red. That doesn't show up as well, and the other red is a light industrial. Pink shows up as more of an office district on there. The best example of that is in the northern portion here of 81. That's a good example there, as well as along 81 in here as well. There's black and gray, which is shown as mixed uses, which there's a little more detail on that later. Low density residential, there's a lake residential, medium density residential, which may mean either, say, the traditional R2 district you used to have, or just a higher density single family residential district, similar to what you just created with the R1C. Which, by the way, it's handy to now have the policy that allows you to have that R1C. But the high density residential, that could be, again, a high density single family, but it's likely to be more apartment sort of living. Manufactured home. Areas identified as campus and civic, again, both of those, depending on the degree, how you want to handle those, they could be one and the same. My suggestion, if you're asking deep dive, is that you're going to create a campus district before a civic use district. Suggestions: central commercial, highway commercial, regional commercial, and neighborhood commercial as far as the sorts of uses. The neighborhood commercial is the traditional, that's the clustered neighborhood sort of commercial that we've had. It's going to be at your intersections of collectors and arterials, that sort of thing. That's going to be the neighborhood standpoint, the neighborhood cluster. The regional commercial is your shopping malls. That's what it amounts to. It's a sort of thing, the regional commercial is a sort of thing that you expect people to come from Hayti, Hamlin, Brookings, everywhere to come and shop here. The neighborhood commercial is a sort of thing that you expect subdivisions to show up at. That's the difference. The Highway commercial is going to be more of that traditional highway traveler sort of get them in, get them out of here, is what that is. There's some mixed use. This gives more detail on what those mixed uses were. I want to go to page 72 here and just show, or page 172, and just show this table to be able to correspond those as you look at this. And maybe you did your homework and went through it and looked ahead in the book here. But something that we see in more and more land use plans I thought was very important in this particular plan was to have a table such as this where we reference back to what is going on the property. So you can see in this table, low density corresponds to that color in the map. It's an R1, an example of the sorts of units per acre we're having, the sorts of land uses. And then on the side, you can see from the air, that's what a subdivision that's R1 looks like. Same thing with your lake residential, also low density. You can see from the air, this is the unique standpoint that we've got going on in a lake residential district. We don't have that. I hate to say it, we don't have body of water coming in most of the residential district, most of the R1. Medium density residential, this again just shows you, I mean, you can see the cluster down, you know where this is. I mean, this is the heart of town, is what it amounts to. Probably this, actually, I'll clue you in, this is north central, right around 10th. High density, you can see an apartment complex, what that looks like, what it corresponds to, what some corresponding zoning districts would be. Anything with an asterisk would be a zoning district that may need to be created in order to handle it. The R4, you can see a manufactured home court, office district. Here's some pictures of what an office district would look like. One is what we have offices already going on North 81. The other is a mixed-use development that's going on in Sioux Falls that has offices on the bottom and apartments on the top. But you also see some of the characteristics you see is landscaping, you see trees, you see grass, you see areas that are open and those sorts of things. Neighborhood commercial, got an example in both Watertown on the bottom and a town that's to the south that shows, again, it's just a neighborhood cluster of commercial uses into there. Things that you would expect the neighborhood to use, but you're not expecting the giant steakhouse to show up there. It's not the national steakhouse location. Your regional commercial is one that would be a new zoning district that would ultimately take up a lot of what is Zone C3. That would wind up carrying a lot of the retail services that are the things that you expect. Where you want the national chain to come, that's probably where you want them to come. Highway commercial is what I said, get them in, get them out of town, and fly through. Central commercial is your not uptown area. The formerly called uptown, but some examples just as far as it took some from some other towns just to show that you're having walkable areas is what it amounts to. Uptown, standard uptown, you can read through these. I'm really not going to go much farther. You can see how this is laid out.
I think this is probably one of the most important parts of the land use plan. If you reference the map and then you reference what the expectation is of that. So when we're looking at subsequent permits or rezonings, and you can use that as a reference guide to go back.
The only one that is not within here that is suggested throughout the ordinance is one that goes along with some discussion that I know Brandy had brought up here actually as well, which is it would help us out in some of that, and it's a zoning district that frankly we got rid of because no one was zoning to it, and it's the old I-1A zoning district is what it was, which was a combination between some commercial and some industrial aspects. The best example of that I see is what we have south of Walmart, where we have very well-designed industrial setup back there where there's a lot of green space and there's, building standards are nice. A lot of the work is being done inside. That's something that's not listed in here as a suggestion, but it may be something we want to look at.
Do other communities refer to something like that as a high-tech industrial? I've seen that in practice before.
There are a lot of communities have gone to and then away from a design review sort of a district is what it amounts to. Basically going back to that form-based is what I'm talking about, to where here's the deal, make your building look like this, have your lot look like this, we could care less what's going on inside of it. That's the bottom line of what they've looked like, and that's where some of these come on with the campus. And frankly, that's a little bit of what our business park district is. And so that's where some of that comes in. So we've already dabbled into it. I think that we can probably go beyond wading into this sort of an idea now. I will happily yield the floor if you want me to, or we can trudge on. It's really up to you. But it's clear we're probably at a point where it'd be wisest to just.
I just have one comment with, as far as the mixed uses, I think that we should look into that, and that should be a priority. And I guess with the PUD, they're pretty cumbersome. But basically, right, for mixed uses right now, the PUD is the option that makes sense. I mean, it's the only thing that's really available. So I think that focusing on that and what we would be okay with, and we kind of talked about it as far as trying to implement resorts as a conditional use in the R1 single-family residential district, and what we would need to require to protect the established zones, but then also kind of move along with the times and what is economical for development. So that might be something that we want, that we'll see in the near future as trying to implement.
So I know I jumped out of order on this, but I really think that that's, when we're going through it, rather than leading up to it, I was going to be referring to this throughout anyway. I think we're better off to look at this. I think if you spend some time in between here and the next meeting, it's not out of the realm of possibility that we'll get through the future development as well outside of city limits. But I really want to make sure. I mean, the redevelopment, I expected it was going to take a while because, frankly, there's a lot we got to talk about. So,
Are you anticipating going through more of these at the next meeting then?
Yes, I am.
Okay.
The plan is let's just go through it at the next meeting. And
I do have some
down there.
comments on some of the future ones, but
Let's
I'll
do
hold
it.
them for the next.
Let's
then.
do it there.
Yeah.
Yeah. Anything, I think, let's just go through, we talked about McKinley and we talked about Lake Compesca. Was there anything else in those areas that you feel like that I glossed over in that amount of time? If not, I'll reserve it. We'll wait until next time and we'll talk more. And you can also get a little more familiar with this table in there as well as those maps. Sound good?
Sounds good.
Okay.
Thank you, Luke.
Thanks, Luke.
Item 5 on the agenda is open public comment period, but it doesn't look like we have any. Do we have any new business, Brandy? I know you had some old business.
Okay, so, and as Luke alluded to, we will wait on the acceptance of the revisions to the draft updated comprehensive land use plan discussed in meeting number 2. And then, as I said at the beginning of the meeting, that I would like to discuss the R2A front yard setback. And Blake, you had provided some additional information, and then I've done some research, not as much as I would like, but I would like to kind of have almost a work session with you guys to see if you're kind of on the same page that what I'm coming up with. So basically, and I'm showing here on the GIS the different areas that are zoned R2A, and a caveat with these is that no new development can be zoned. If somebody came in with a new subdivision, they cannot use R2A. So basically, it's retrofitting all these old neighborhoods and trying to allow them to improve their property, but as well as not encroach horribly on established setbacks. But what I found is that typically, like these neighborhoods are mostly along local streets, which that right-of-way is 66 feet. And a lot of these are 80 feet, and which is what a collector route would be. So, and then there's also some 100-foot right-of-way, which is what arterials would be. There's 3 that are 100-foot right-of-ways, and then like 27 that are 80-foot, and then, or no, 12, no, that is right, 27 that are 80-foot, and then 12 that are local, which is 66 feet. So what I would propose would be that if it's 66, so if the properties that are zoned R2A are adjacent to right-of-way that is 66 feet, which is a local street, that setback would remain 25 feet, or we would reduce it to 20 feet. And now the 25-foot is outlined in an ordinance because of the Clearview Triangle. And I don't know if you found it in 216501. Is that?
In that information I sent on the Clearview triangles?
Yeah.
I did a search through the full book, and I pulled all the references into that document.
Right. And I think that the one that's most applicable is the one that's in the outdoor storage. And then that is where that, and it's in definition too, that it's 25 feet and then a line drawn from the property corners and then a line drawn straight.
Yep.
As the Clearview Triangle.
From the property corners. Then there was some discussion on what makes the most sense. Should you pull it from the curb or the property corners? In the Gateway District, we've actually got it in there as from the curb. Actually, it's in there 2 different ways in the Gateway District. One says the curb, another says the center lines of the roads at the intersection. What I'd like to do is to develop a Clearview Triangle section of the chapter and reference it in every place that it needs to be referenced, and have one set of standards for the Clearview Triangle. I think it makes most sense, honestly, to pull it from the curb. It's clear and easy to understand going off the curb. And if we get some visual drawings in there, I sent you some examples that it was kind of an excuse for me to use AutoCAD because I don't get much of an opportunity to do that anymore. But I don't know. It makes sense to me to go off the curb versus property line. Nobody knows where the property line is most of the time. And then in instances like this with the differences in right of way, I mean, if we're going by the curb cut, it's consistent all the way through, right?
Right. But then also, just to expand off of that, so if it's adjacent, just because 66 feet is our, it's our standard local street right-of-way. So if they are adjacent to that, then to potentially leave it at 25 just to have some consistency, although a lot of these properties, they already don't meet that setback.
Correct.
So, and that's why potentially going to 20 on those, but then the properties that are adjacent to 80 feet of right-of-way, that they would be lessened to 18 feet. And what I did there is I just subtracted the 66 feet from the 80 and then divided it by 2 for both sides of the road, which would lessen it down from 25 to 18.
So on the ones that are actually local streets and 66-foot right-of-way, how wide is the road? So how much boulevard do we have on each side?
Well, the roads are pretty standard, but the boulevards, so like with the 66, if you're assuming that it's a, 38 is most typical foot road, and then, and I took 38, saying that was the back to curb. And so then, like, when I did the 66 feet, I subtracted that 38 and got 28, which then leaves 14 on each side. So then when I took the 80 and subtracted the street out of there and got 42, divided that by 2 and got 21, so then I subtracted the 14 for what the local street would be. What the boulevard on a typical local street would be.
14 feet?
Yep.
But if you're gonna move this from the property line to the curb, does it really matter? I mean, whether it's collector or arterial or
Right.
whatever the right of way is, I mean, you're gonna have to jump it up anyway, like to 50 foot from that point anyway to do it. And it
So-
shouldn't matter what one it is, as long as you're following the curb line.
Yeah. So at a 50-foot, which is what we have in the Gateway District, off of the curb, on an average local street with a 14-foot boulevard between the property line and the curb, they're almost identical, 25 foot from the property line, 50 foot from the curb. It's very close. And I had that in that first illustration. And that's where, you know, I mean, we could probably standardize. It's really going to make almost no difference.
Well, that's what I'm looking at, is just something, okay,
Right.
it's 50 foot from the point of the curb every place, and instead of me having to run back and say, okay, what zoning district, what's the width of the road, whatever else. Yeah.
But then my further question to that is, so if the Gateway District is 50 feet, do we need to have 50 foot in this local residential, or do we drop it down to 40 foot or 35 foot?
As far as standardizing it, why would we want to change it for this district to measure off the curb cut? And why wouldn't we just change the setbacks for the property
I
line?
think it's based on use again, isn't it? I mean, and also
Yeah.
functionality of the road. I mean, if I have a more intensive functionality of the road, if it's 50 feet at the gateway, and that's 35 to 45 mile an hour speed limit, that's why you want a much larger triangle than you would at somewhere where you got speeds anywhere between 15 and 20.
So, yeah, and that was an example that I had sent to Brandy too, where a lot of other communities are looking at it based on whether it's a local street or an arterial street. The intersections between a local and an arterial are a little bit different because the speed limit,
And
if it's a controlled intersection.
And I believe the speed limit at every intersection in the city of Watertown is 15 miles an hour. It's not 25. I just know from personal experience.
Are we going to run into, I remember before we gave a variance on a garage, and this was my first time around, so you would have been there, Blake. It was up northwest part of town. And that garage was going to be, because of the boulevards all being kind of different up in different sections of town, that structure was going to be only 6 feet from the sidewalk. Do you remember that? Or 8 feet? I mean, it wasn't very far. And I can't give you an address and I can't give you a date, but are we going to run into that all of a sudden being not, we got our clear view triangle, but now all of a sudden we're really close to a sidewalk? You know what I'm saying? Know where I'm going with this?
I think we know how many squares we have in there, and there's 4 corners in every square. So we figure out how many instances this is going to happen, and we try to bat for the greater average. And so if we've got 200 blocks, we've got 800 corners that we got to deal with. And at those 800 corners, if we can fix 600 of them so we don't have to see 600 of them over the course of the next 5 or 10 years, isn't that the win? And you have to deal with 200 oddballs.
I think we're talking about between 15 and 25 feet. It's 25 feet today. I think 15 is probably on the bottom end of the spectrum. So 6 feet.
I'm just
I
throwing
don't
it
think
out
we
there.
need to go
I'm just,
that far.
But where I'm going with these right-of-ways is because they exist and they are oversized for what
Yep.
type of road it is. So then to finish the 100-foot of right-of-way, then what would be for an arterial, to take that and take what a 14-foot boulevard would be, or a 38-foot paved road, that setback would then just be 8 feet in relation to if it was adjacent to a local street. Because you're having, it's almost like so if you were going, so here's Broadway, and if you were going from the edge of or the back of the curb, and you're going 14 feet, this is typically where this property line would begin, but it's still the right-of-way. So then, if we're saying, but the property line is still 7 feet from that point. So you're still getting a pretty large setback from the street. So then if we would even put it down to 5, then you have a 5-foot setback. But you're still technically 30 feet away from the street, or 26 feet away from the street. So you're getting a 25-foot setback, but usually we don't include that 14 feet either. So it's kind of, it's difficult, I guess.
I'm fine with doing the language, in relation to the street. I would just prefer the measure to come off of the curb because it's easier for the property owner and the staff to be able to differentiate.
Well, actually, when I first started here, they were all off the curb. We changed them to the property line since I've been here.
Which is okay if you're reviewing it from a permit standpoint and you got the site plan, but if you're looking for, so Clearview also covers landscaping requirements. So from a compliance standpoint, driving around town, I don't know.
For us, it's not that difficult. It might be difficult for a homeowner or something like that, but it's not that big a deal for us, so.
So Brandy, that's a good corner right there. You've got two different sized boulevards. I want to add on, how far out can I go with this setback? Because you've got, what are you considering? Broadway is a 100-foot street, isn't it?
Yep.
Okay, so
From your,
if you put your mouse where I can go to the east and where I can go to the south.
okay.
Where's the edge of my house?
Are we talking setbacks or Clearview Triangle, or is one dependent on the
Well,
other?
are we
I'm getting
talking all the
confused in
same
this
here?
conversation, I'm sorry.
It's
Not clear. I don't think we should
It's
focus on the
both.
Clearview Triangle necessarily at this point, but I think just to get a relation of, because if we're going from the Clearview Triangle and we're going 50 feet over, I mean, I don't know why we're focusing on that.
The conversation came up that if you put your setbacks too small, then you could potentially place the building within what we have defined as the Clearview Triangle. And so when you're looking at it, you're looking at both. You don't want to write the ordinance on the setbacks so that it could potentially be put into it. I mean, clearly you'd have to comply with both, but we want to make it simple, right?
But how the ordinance is already written, it's already in the Clearview Triangle.
It is, right, because we're going off the property line.
So with this situation, 6th Avenue is a collector 80-foot right-of-way, so then how I have it proposed that it would be, I am actually saying 15. So this one would still not meet that setback.
So where's 25 feet if you come off of that, so our current setback?
Right here,
Yeah, and then coming from the other direction?
about right there. So actually, that looks like it was an addition, just by the roof. And then off of this, the 100-foot right-of-way here, I have it proposed to be a 5-foot setback. So then they could come to here, and then they would still have 26 feet to the street. Which right now, so that would be 34 total, no, 26 total. And right now with our 66-foot right-of-way and a 25 minus 38 divided by 2 plus 25, right now we have them set back 39 feet from the back of curb.
I think it'd be really good if we could illustrate the examples that you're proposing and look at.
Give us a real world example too. Use this corner, draw the lines.
I'd like to see the overlay of the buildable area on top of it, and what percentage of the lot then is buildable area, because that was really what triggered this whole thing for me, is that many of these lots had like a 17% limit on buildable area. Well, I mean, that's an unrealistic expectation, especially if we're talking redevelopment. I mean, if we want people to redevelop, and you can only build on 17% of your
It's
lot.
not going to get redeveloped.
Actually, within the last week, we had 2 people that want to redevelop lots in the R2A, which is why I kind of want to expedite this, catalyze.
That's a bare lot probably, right?
No,
Adding on?
it would be a tear down.
Well, okay, so we'd be starting with a bare lot. would be a whole different cat in my book.
Still have the same requirements, the same setback requirements apply whether
No,
it's-
but if they start with, if we're gonna do redevelopment, if they're starting with a bare lot and going, I think then a whole set of different rules could apply, don't you
But
think?
the lot size and shape is still a lot smaller than
I know,
an
but you're
R1.
not taking this existing home that is, I don't know.
But
I-
for redevelopment purposes, as we have the R2A, they cannot build on their lots, because a lot of these are 50-foot lots, and then
Yeah.
having a 25-foot front yard setback.
can't do
You
it.
can build a 14-foot wide house, so you can potentially put a mobile home on
But I'm
it.
saying, if you're starting with a whole new footprint, you have nothing there, I mean, then,
The same rules apply whether I have nothing there or I got an existing house there. And you
So
can't,
let's-
and we can't separate that. So what the issue comes in is how do we maximize the amount of space that can be built on the 600 corner lots in the R2A zone? That's really what the question is, right?
Yep.
And so I think what it is that so what comes down is what can we stomach as far as encroachment into, you still gotta build everything on your own property line, but how close can you encroach that property line? That's all,
Yep.
that's what we're looking at.
and how close you wanna be to the sidewalks when
Yep.
done. You're gonna look like 81.
Just on the corners.
Oh, you're only allowing that on the corners.
Well, that's the only one that really sees the issue, because they have 2 front yards.
Yeah, 'cause you have two front yard requirements.
So, for examples, these are R2A. This is just down off, just south of Lake Area. And this happened, or is there? So it's 15 feet off the property line, off of 12th Avenue, which is 80, it's just the collector. And it is 28 feet off of, yeah. And then this is 100-foot right of way, so they are like way set back off of there, which what I'm proposing would be 5 to 8 feet off. Because we also do have that inline provision where if the properties within the block are,
Yep.
then you could line up with them. So like they actually, because of where this one is as far as redevelopment, they couldn't go there, so they would have to be in line, which they basically are.
So
But-
that's what I'm saying, so the next house, you're not gonna allow that next house to bump out like the corner house is?
The reason this one was held back by this house because we can't we can't.
I know,
block
but if
their
we
line
change
ability.
if we do the setback, the clear view setback, that one could have went out further.
Well, I think that we should leave that provision in line where if there is an existing house, that it does stay in line. But if there wasn't one there, then they could go up to 5 potentially. Because there is still the clear view triangle is being maintained.
But then I'm the neighbor next door, and I really don't wanna, if I can't build out into that frontage.
The neighbor next door also only has one front yard and then 2 side yard setbacks, so they can build on 60% of their lot, while the other neighbor currently can only build on 20%.
But I'm now looking at the side of their house.
No, if the house is pre-existing, that we would still have that inline provision where they would have to adhere to that. We don't want to disturb established neighborhoods either. But as far as the corner lot, then, being that they only have a neighbor on the one side, they might be able to, either their neighbor does have a lesser setback than 25 feet, so they can be in line with that. But then adjacent to the street, at the end of the block, then to allow for a lesser setback based on the right-of-way. Just so we're maintaining safety.
I wouldn't mess with the setback to the north. I'd only mess with the width. Basically, when they're being encroached or restricted on their thing, it's because of the width, not the length of the house. If you leave that at 25 feet or in line with provision, if they observed a lesser depth already, you're gonna keep that conformity, and The only one that's gonna apply
Yeah.
to is the other house that's to the south, it's got a narrow lot anyway.
Well, and that's what I originally proposed, was to differentiate between a primary and a secondary front yard, and we only have one other location within our ordinance that talks about that, and that's the outside storage area. But we could better define that in how we're gonna apply it to the setback. And if you do look at most of those old houses, they really are, or were designed with that intent.
So then, like, this example here, so this 13th Street is an 80-foot right-of-way. The setback would be 15 feet because of that collector right-of-way. And then it would stay in line, but say that this was to be ripped down, they would have to adhere to 25-foot front yard setbacks on both sides, which the front already is, but they would have to anyway because of the inline provision. So that would be on this block, it would run here, and
Well,
then.
why would they have to be that on, if they're not in line with, they're in line with the stuff to the north, but why would they have to be in line with the east if there's nothing, is there something to the south of them?
They don't have to be in line to the east.
The inline provision only allows you to observe a lesser setback if the adjacent properties have.
Okay.
Otherwise, you're required to go 25 feet. I mean, if the adjacent property is 30 feet, you can still build at 25 feet.
But then also, if we change it and we say, if you are adjacent to a 100-foot right-of-way, that you can have a 5-foot setback, but not if your neighbor is already established, and then you have to adhere to the inline provision. But if it's,
Well, then the discussion's really is over because we're not doing anything. If you're still gonna mandate 25-foot front yards on the corner, regardless, you're not gonna gain any extra space is what Dale's
no,
talking about.
because
You would
then-
if you treated the second front yard as a side yard.
But it would be a lesser setback because of the adjacent right-of-way. And that's what I'm saying with this, like, where this house is today, 15 feet would get us to where this house is sitting. But if they would tear this down and start over, they would have to set back 25 feet.
Right.
So, because we can say 100 foot, you can have a 5-foot setback from your property line, 80 feet, you have 15 feet setback.
Well, whether it's a tear
Or-
down or it's a new development, what does it really matter? Why are you penalizing? If we're okay for them to encroach the side yard as an add-on to the property, why wouldn't we be okay with them allowing a new construction on that lot in the same situation? That makes no
Just
sense
to
to
try to
me.
limit variances.
We wouldn't require a variance. If it's a new structure going in to replace and we're comfortable with that being an expansion, it'd also be good if I tore it down. If we're trying to encourage redevelopment in certain parts of town with this R2A, why are we making it so cumbersome? It's more of a rhetorical question. You
Well,
don't have to
and
answer it.
okay, so then how would, if these guys came in, wanted to tear down, how would we regulate them?
I would say that you would start by requiring one primary front yard. So if one has to be 25, pick one. The other one has to be, you can say it has to be 25 feet unless you would allow up to 12 and a half feet as long as you match up against a certain type of a road.
That's what I'm saying.
Well, I did get that from you.
It shouldn't matter whether it's new or tear down or addition.
Yeah, that's what I was
Anything.
saying.
It should be applied straight across the board.
Yeah, the difference is between
addition or tear,
what
whatever.
would happen today if it was tore down and you had to rebuild it
Oh, I'm
versus-
sorry, I thought you were saying going forward, that's what we would have to require. I'm sorry, I misunderstood exactly, I'm sorry.
Okay, so like, for example, this house, say they want to tear it down, right here is a 25-foot setback. And then their other 25 feet would probably put them about here.
But that's
So-
what the ordinance requires today,
Correct.
Yes,
and we're gonna change that,
yes.
okay.
So, and then to limit, so they would have to come, if they wanted to build anything, they would have to come to the Board of Adjustments and ask for a variance.
I don't wanna do that.
Right,
Mhm.
and that's what this is trying to solve, so that's why, when I started looking at it to try to distinguish between the different properties and the corner lots, that's what made most sense is that you're not necessarily encroaching on the Clearview Triangle at all, because the right-of-ways are are way larger than they would be if they were a local street where these residential neighborhoods would be.
The only thing that I would say is if that secondary front yard is adjacent to a local street, I think we still need to go down from 25 feet.
That's what I'm proposing, 15.
Okay.
So I have a table here that says if the right-of-way is 66 feet, the setback is, now this is open, it can be 25 or 20. I think that we should keep it consistent with what we do with other local streets adjacent, just to have some consistency, to say 25, if you're adjacent to a 66-foot right-of-way, which is minimum. And then if it's 80 feet, we would allow 15 feet. And if it's adjacent to 100 feet, we would allow 5. Unless there's an existing structure that's, the inline provision would apply.
I would never like to see it go less than 10 feet, because right now within the ordinance, you're allowed to build a deck, uncovered deck, that can encroach 5 feet into your front setback. So then you'd be able to allow these people to put a deck right up to the sidewalk or property line.
I see what you. I think, I like what you're doing. Come back with some visuals.
Yeah,
Because
if we can.
because I'm having a hard time visualizing a couple of the things that you're saying. So take your table, do some drawings, have some real-world examples on how that fits, and then I think I would have a better way of grasping it.
Yeah, if you just overlay the graphic of the buildable area. I think, so on the 66-foot roads, though, I think I'd like to see it smaller than, did you say that was going to stay 25? Because I wouldn't even have a problem with it going down to, so 66 foot, that would put a 14-foot boulevard to the property line.
And go with the 10.
If you go, yeah, even at a 10, you're still almost 25 feet off the curb.
That takes
I was thinking 15, but I don't know, it's somewhere in there.
I think, again, if you're trying to maintain the 125-foot front yard and the other one giving you this flexibility, and that's where you're making up your difference for reconstruction, right? That's what you're saying?
Brandy, would you do that primary front yard versus secondary?
Yeah.
What do you mean?
Primary, basically your front door. I mean, that's generally where most people think is your front yard is your front door.
And you can see almost every one of these blocks, it's the narrower
I don't know that
section.
you can do it that way, though. Because if this guy's front door faces the east, he doesn't get any relief that way, and then he
Okay.
gets relief to the north,
Which-
which is
It's the narrower section,
counterproductive. We
right?
just needed the narrow width of the lot.
It's the
needs-
narrower right-of-way.
Right.
Well, the narrower lot.
So that's what it's, if it's a budding or it's adjacent, then, and that's, because I thought about the primary and the secondary thing.
It should be the width versus the length, not
Yeah.
the primary and secondary.
Yeah, if we relate it to, because I mean, they're all long, narrow ones, so just relate it to the shape of the,
I get it, width versus length.
right. I think everybody's on the same page. I think if we get some visuals here, we can dial it in and make an agreement.
We're close.
I was thinking we could just look at real-world examples.
Yeah, it'd just be really good to have the real world examples with like a graphic overlay to see exactly where it is. It's kind of hard to see when you're putting the stuff up on the board there.
Okay.
Make it like bright pink or something so it stands out.
I think there's just so many examples, and I made 2 examples, but I didn't even put them on here because it's like so wide open.
Yeah.
That's why I thought going around town and just looking at specific properties and then seeing how they would line up with those setbacks, that's what I thought would be more effective, because literally no intersection is the same. So, I mean, it's hard,
Yeah.
but I will pick out some examples and just have
And again,
a
the thing
few
is,
illustrations.
if we get it and you hit 70%, that's still better
Yeah.
than nothing.
Can you include that table that you have too in the agenda packet for
Yeah.
next time? That'd be perfect.
Good job.
Thank you, Brandy. Yeah, this is much needed. Appreciate it.
Yes, you bet. Otherwise, I don't have any other old business.
Any executive session?
No.
Motion to adjourn?
Second.
Motion and a second? All in favor?
Aye.
Opposed? We're adjourned.